Legal 112, this is your podcast for week number 2. And our focus this week is to identify practical guidelines for beginning our research tasks, to introduce some basic strategies for effective research. We'll talk a little bit about developing that effective plan for working with authorities, legal authorities, and some guidelines for ending your research, because sometimes we can struggle with when we need to stop or could or should stop. In my experience, and the way I've been taught and the way I believe you need to approach legal research, there are only 2 inflexible rules that you must follow when you perform legal research to ensure that you comply with your ethical duties of competent representation. Remember, we talked about that in week 1. Competent representation, our legal and ethical duties. Number 1, you must read the full version of anything you intend to use as legal authority. You must read the full version. Along the way here, you're going to find that, for instance, in Lexis, when you pull up a statute, it will lead you to references to cases, articles, other resources that cite and talk about that statute. If you don't open one of those resources and read the entire thing, because it will give you a nice little summary including the citation and reference to whether that particular case is still good law. If you don't open it and read the entire thing, you're not holding your end of the bargain. You are not doing the things expected of you. And for lawyers or people who have a license, they're violating their ethical duties. And sometimes that can cause them to lose their license. I've seen that. I was part of a case one time where a lawyer who was representing a lawyer I was suing in malpractice because that lawyer missed the statute of limitations and then lied to a little old lady he had agreed to represent. And in court before a judge, the lawyer representing the lawyer who had committed malpractice relied on something that he had read in a summary provided by Lexis, which is a secondary source. It's a private profit-making entity that provides access to or references to primary authority. And instead of just going the extra step and reading the case and then doing the next inflexible rule, verifying that that case was still good law, he represented to the judge that it was good law, when in fact the case had been overturned. Eventually, that lawyer ended up before the Attorney Registration and Disciplinary Commission with his client, the lawyer who had been found to lie about representing and then missing the statute of limitations for his client. It was a big mess. But that lawyer failed to meet the expectations of these 2 inflexible rules. Number 1, you must read the full version of anything you intend to use as legal authority. And a lot of times, guess what? You have to read it 2 or 3 times. Maybe more for statutes. I always read, if I'm going to rely on a case in court, I always read it at least 3 times. I read it once when I determine, hey, this might be good. It might help me. Or it might explain something. 'Cause sometimes things don't help us. They just help us explain something. And then sometimes we even have to read something that doesn't help us so we know why it doesn't help us. But I read it the first time. It applies. Let's just say that. I read it a second time to be sure why it applies and if I'm on track with my thoughts initially the first reading. And that time I might highlight or make some notes of things that I want to go back to. And the third or future, more than third, readings are used to extract the things that I'm going to use or rely on or need to have available to understand if it's helpful or not or why in both directions. So that's the first and flexible rule. The second one is that other that I mentioned, that you have to verify whether that authority, that primary authority, is still good, whether the statute still applies, whether it's still applicable to the time frame of your issue, whether or not the case is still good case law. Cases get overturned. Points of law over time, they may be adjusted or changed due to changes in our society, changes in application of various things in our society, things that reflect changes in expectations of the law. And we see examples of that every single day. So you have to go in Shepardize or Keysight that we talked about last podcast and verify. Now, as long as you perform those tasks, you will find the best answers towards solving your legal research problem or issue. And I say the best because, as we also talked about, and it may take some radical acceptance on your behalf, but you have to accept that we, most cases, are only going to provide the best answers, not the answer. And as I think I mentioned in the orientation, 2 plus 2 doesn't always equal 4 in the law. It's rarely black and white. And so we're finding the best answers to help us understand what our position likely will be viewed as by whatever tribunal court body that we're appearing before to ask for some sort of resolution to our issue. Now, if I'm breaking down some sort of issue, some sort of legal problem, there's usually a thought process that you go through. And I would suggest that you write these things down and you start thinking in these terms. And some of these things will become second nature and you'll just fly through these considerations. But until it becomes second nature, I suggest that you take these 5 core issues, you write these down, and for every problem that you try to solve by the law, you go back and you go through these as you sort out what you are dealing with and where you might or should look to solve that issue. The first one, is it civil or criminal? Is it civil or criminal in nature? Because that's going to determine, for instance, in Illinois statutes, which statutes you end up in. Is it civil or criminal? In family law, for instance, in wills, trusts, and estates that you'll have in the spring semester, those are civil in nature. If you don't know the difference between criminal and civil, do the work and figure that out. But at this point, you should have a good idea of what I'm talking about. Is it civil or criminal? What's the jurisdiction? Is it federal or state? And then if we're talking about something that may go before a court, Which court? And that's something you're going to practice in your assignment for this week. What type of action is it? Typically, the type of action depends on the remedies available. What is sought? Is it for punishment? It's probably criminal, right? If it's for money damages, for equity, for fairness, for enforcement of a contract, what is it? What's the action? What is the thing that will solve the issue, or one of the parties or the other is trying to get to solve the issue? Are there any potential defenses to that action? And then I always want to think, and the final one is, what are potential remedies? Again, that's going to go back to, and in part flow out of civil or criminal and the action. But you want to sort of write down what are the potential remedies? What's going to make this issue go away? And think in those terms. Now, when we want to ensure that our research is sufficiently thorough, I think you start with a secondary source. Now, you can use an encyclopedia or practice encyclopedia like ICLE, the Illinois Institute for Continuing Legal Education, that some of you have experience with, and if you haven't had experience with that, go jump in and check it out now, because you have available to you every resource from that service, which is several $1,000s worth of a benefit to you each and every semester you're here. But the people you will eventually be employed by will likely never have that type or level of access. They may have access to some of what ICLE offers, but ICLE is a great resource, especially for Illinois-specific things. And if you've had other classes with me, you know that I leverage those ICLE volumes and the service, so you don't have to buy textbooks in some classes. But let's face it, you could even go to Google, right? As long as you remember those things that we've suggested, like .gov and .edu are better resources than some of the private entities, and there's a lot of law firms that offer summaries of the law on topics that they practice in, or areas of law that they practice in. But I would use, if I'm a student in this class or if I'm practicing in Illinois, something like ICLE. And there are others. But you want to use a resource like that to get some background on the topic you research. You want to do a little pre-work so that you have an idea about what it is you're dealing with. And there are plenty of those types of resources that if you take the time and you read and you put that time towards you gaining some understanding of the general topic, you're going to be better prepared for your research. So you get that background on the topic you intend to research. When you're looking for cases, you should always consider looking to statutes if you aren't finding anything directly in a case-focused research session. Because statutes regulate nearly everything we do in our lives. If there is a related statute, go to it. And if you go to the annotations to that statute section, annotations are those, if you page down from the statute in Lexis, you will see that Lexis breaks out for you, and Westlaw does the same, references to cases by jurisdiction, to case law, court law, by jurisdiction that references that statute. And if you remember, cases or courts interpret and explain statutes and their application to specific situations of facts, specific cases, specific issues and facts in specific cases. You'll see that the annotations are broken down by topics related to most likely what your issue is. And then once again by jurisdiction. So if you know your jurisdiction and you know your topic, this is a good way to find a case that may be related to or applicable to your particular issue. If you can't locate any cases through annotated codes, through treatises, through encyclopedias, through ICL, Google, and again, this is going to be rare. You're really going to have some funky issue. You can go to other secondary sources, law reviews, bar journals. Sometimes you really have to dig. I once had a case on something, a cause of action that was alleged as res ipsa loquitur. And I'm not going to bother to spell it, and you can try to look it up if you choose. But essentially, I was defending a company that applied fertilizer to a farm field, and the corn that was fertilized in the field, the corn seed, did not grow. And the farmer, the plaintiff, and his lawyer couldn't show that what my client did in applying the fertilizer was in any way improper. It wasn't the wrong stuff. It wasn't something other than was ordered by the farmer. It wasn't ordered or applied at an application that was improper or not agreed to. None of those things. And so they alleged that it had to have been my client rather than the fact that it had been an abnormally dry spring. There was little to no moisture, that the farmer was trying to grow corn in a hybrid seed that he had developed, what didn't come from anywhere else that we could track or do anything like that. And that my client had no control over the sun, the wind, the rain, the conditions. My client did what he was asked to do, applied what he was asked to apply in the way he was asked to apply it and the contract called for. That I'd never had a res ipsa loquitur case. There's few references in the modern law books or case law about a res ipsa loquitur case. And that is most likely probably because of what I said earlier, that we have statutes that regulate nearly everything in our lives, or administrative codes, and we have all sorts of case law that flows from that. And we've established liability law through statutes and case law to the extent that we have causation and paths to how things occur. And res ipsa loquitur was a cause of action that sort of, has had its time to a large degree. There may be applications, but this wasn't one of them. In any event, we had to dig deep. Dean Weghorst, who was my paralegal at the time, and I had to dig deep. I believe we even had Chief Judge Gorman, who was working in our office helping with that particular case. It was not the norm. Okay, so if you can't find anything through those other paths, through just case law research or going to the statutes and looking at the annotations, that's the route you go. And then finally, you shepherdize or key cite your cases. You verify your cases and statutes to ensure that they are still valid, and you follow that process all the way through. Because when you shepherdize a case, for instance, it will lead you to any cases that have come after that case that have cited that case. And as you get some practice in shepherds, and if you've taken a look, as I hope you have, and I hope you continue to go in and take a look, shepherds helps you determine if the points of law you're relying on from that case are still good. And if there's any case that cited it, if it's been changed, if it's been challenged or questioned, or there's any caution you should have about relying on that point of law. And it provides you two updates. So if you have a case that was valid law in 1996 and it still looks like it's good law, but there's, several cases in the last 3 or 4 years that cite that same principle of law, I'm going to want to have one of those newer cases to go with whatever that older case is that I'm relying on. More is more when we're talking about case law. That's a good point to raise right now. And so if you have an older case but you have newer cases that cite the same principle of law, you can go ahead and reference that older case, and especially if it's closer on the facts, but you cite those and reference those newer cases to show that, hey, it's still good. And shepherds or Keysight help us verify that law is still good. Now, developing your search, okay? Those other questions I gave you, those other considerations help you develop where you want to look and what you're looking for. But in developing your search, there's certain things that you may want to do, or certain other deeper things you may want to flesh out. When I say flesh out, on a pen and paper or on a document on your computer, actually type these things out. Who's involved? What's the issue? Where did the activity take place? So in other words, that goes to jurisdiction. Why? Why did this issue develop? How did the problem arise? Those kind of questions will help you in your search by providing you with, hopefully, some words that you can use in your search queries. It'll help you dig deeper. But let's be clear about something, okay? And I alluded to this in week 1. This is no easy task, legal research. Legal research requires that you put in effort. Legal research requires that you leave no stone unturned, that you follow the process, the legal research process, all the way through. And you don't ever think that it's going to be easy. And as I alluded to in week 1, I've been doing it for a long time. There's a document under modules on Canvas that is your legal research process guide. It's a fairly simple, straightforward process, but you follow that process through. If you verify the case, it leads you to other cases. You have to find those cases. You have to open and read all the way through those cases. No shortcut. But you have to follow that process all the way through. As you do this, as I had alluded to earlier, you sometimes lose sight of or struggle with, when do you stop? So, when do you stop? Well, sometimes in cases, economics will govern the scope of your research. So be efficient. You have to be complete with your research. We have to do a complete job. But when I say economics may impact it, a client may not pay for or want to pay for all of our research time. In the orientations, I talk about organization and the expectations there. And let me give this commercial now. If you aren't writing down everything you do in legal researching anything, and if you aren't keeping track of what you've looked at and what you haven't looked at and where you left off, when you get pulled away for a phone call, a discussion with the lawyer or a client to go and do something else, because you will do that, that will happen. If you haven't been keeping track of what you've done and where you've left off, you're going to have to go back and redo those things. You cannot keep this type of task in your head. You have to document this task. Research is something you must document. You must keep track of what you did, where you looked, what you looked at. And if you think that I'm fooling on that, if you think that I'm just BSing, well, go ahead and try it. And for class, you're just going to cause yourself headaches. If you practice that way in the law office, you're going to cause yourself not to have a job. Because no client wants or should have to pay because you didn't do your due diligence in keeping track of and being consistent keeping track of the work you're doing. So when you got pulled away to do another client's work, you have to come back and redo your work, and then you're going to want to charge them or bill your time to redo your work. So economics may play a part in it, but no, it's not acceptable not to keep track of what you're doing. And if you keep track of what you're doing, you'll be efficient. Now, one clue that your research is complete is if you go through that process, if you follow that document that I just referenced, and you go through that process and the steps of that process, and if you want to pull that document up or have it with you and you want to look at that document as I say this, one clue that your research is complete is you keep bumping into the same authorities. So you're going through and you're shepherdizing and you're opening things and you're reading things. Well, if you've come to the end, if you keep bumping into the same things, and typically that's going to be you're at, the current time, whatever month and year you're in, then you probably exhausted your research for that moment. Because remember, if you do something today and you finish it up today and say, this is the best that's available today, but the case goes on and it's 6 months later, you need to go back and make sure there's nothing newer. You got to update your research always until the case is done. One of the things that may trip you up is beginning in research or beginners in research often lack the confidence to stop researching because you're convinced that there's one perfect case. I'm looking for the needle in the haystack, the one perfect case to find that they're, on point on the facts and the issues. And there's rarely, as I've said before, such a case. But with time, you'll get the confidence and you'll understand that, and things will become more intuitive. One other thing to keep in mind, as a general rule, you will need fewer authorities to support a well-established principle of law, and more authorities to discuss an emerging area of law or one that is very fact-specific or constantly in conflict. And you'll see this play out once you do more and more case research. Because you will see, for instance, if you've taken my evidence course or my administration of justice course. My administration of justice course, it's really based on some landmark Supreme Court cases from the 1960s. It's the basis for criminal procedure. And while there are new cases that come out of the appellate courts, state and federal, all the time. And those new cases may introduce new things, new issues, especially when you think of technology or how technology plays into committing crimes or solving crimes. The general principles of criminal procedure stem from those landmark cases. So I need fewer authorities for something like that. I'm going to give you 5 tips for successful legal research before I end with some comments on citations. Number 1, be prepared. Number 2, be organized. It's a theme of the program. It's a theme of being successful in the law. It's the only way that you're going to survive and be successful in the law. Number 3, be patient. We can get sped up. We can get sped up by other legal professionals, lawyers, or people in the office, by clients, by timelines and deadlines, by our workload. If you just take a moment to gather yourself, take a deep inhale through your nose, hold it, exhale through your mouth, do that 3 times. If you put down whatever it is you're working on and just do that, and then come back to it, you're going to see it more clearly. Patience. Patience with yourself, patience with other people, patience with the process, because it is a process. It is not quick and easy. It will never be quick and easy. It is not something that you can rely on anything or anyone else to do except your own skills that you're going to develop. So be patient. You need to be thorough. And thoroughness really goes back to your preparation and your organization. If you're prepared and organized, if you stay patient, you're going to be thorough. At the same time, the 5th thing you need to be ready to do is to be creative and resourceful. And that goes back to that point I made about, if you're not finding anything in the case law, then go look at the statutes, because almost everything we do in our lives is probably regulated in some way by statutes. So be creative and resourceful and look at those secondary sources. Build your base knowledge and look at those secondary sources, and then go from those secondary sources looking for primary sources. You want to keep, use, and revisit the resources you purchase, the resources you're provided for here. You want to keep those things somewhere. And as we've said, learning legal research is like riding a bike. And these items may be called upon in later classes or years in your career to help boost or promote your balance in legal research. And as I've made very clear from my own perspective, a long time after I first started to learn legal research, there are times when I jump on and I try to ride that bike and do legal research that I feel pretty darn shaky until I get riding again. But it comes back to you, and it always comes back to whether or not I'm following the process. So follow the process. As I close the first week, I'm going to close this week talking about citations. And remember what I introduced in week 1 and the unique perspective for use of citations in legal documents as compared to what you or how you were likely taught and maybe drilled to view and use citations in your other educational or career pursuits. Think of legal citations as your effort to provide a roadmap and clear directions so anyone can find the legal authority you are relying on or suggesting is applicable to a particular legal issue. Ideally, you're leading your audience, your reader, to primary law, statutes, and case law, or administrative rules and decisions, or, and that's for the most part where you're going to primarily states or statutes and case law. But sometimes it's constitutions and ordinances, executive orders, treaties, law created by a government body, right? You also want it to be binding, so it applies and must be followed in the jurisdiction which your issue is located, right? Venue is location. While we're learning legal citations, and then for a long time after, when you're old like me, we have to refer to and use citation resources. We have to make sure that our citations are correct or are providing an accurate roadmap, accurate directions to the reader. So you need to use those resources, and I provided that one document that takes you to all the Cornell resources, and this week you're supposed to go through that process. And you need to go back to that process, and you need to always use those resources for every assignment in this course, because we must cite our authority for every bit of the law we rely on to solve every question and every issue we ever deal with in the law. Use the resources. Don't try to take shortcuts. Put in the time to do things according to the process. And if you do that, you'll become more efficient. You'll become quicker. Best of all, you'll be accurate all the way through. This is your podcast for week number 2 of Legal Research. I hope the class is going well for you. If you need me, you know where to find me.